Well, thank you everybody to take the time to participate in our panel. This panel is part of a wider workshop that my colleagues at Thomson Reuters and I have put together. The workshop is on mining and learning in the legal domain. The workshop will be hosted with the International Conference on Data Mining in December in New Zealand. And due to the timeline and the time zone differences, we decided to actually have this panel ahead of the conference date to allow people from North America and Europe that might join us actually have a chance to participate in this event, because the timeline, time slot that we were given as part of the workshop might not actually work good for everybody. It's actually on December 6th at 8 p.m. So we're going to have a talk, a keynote talk by Dr. Sharad Goel of Harvard University. And he'll be talking about mostly about the access to the fair access to the justice system. So if you are available, we'll put a link to the workshop website if you wanted to attend that talk. That would be great as well. So we have put together a very prestigious group of panelists for you today. Ravia from Thomson Reuters, the Vice President of Legal Practice and Productivity at Thomson Reuters, would be moderating the session for us today. Thank you very much, Ravia, for accepting to take part in this. She will introduce our panelists, but just wanted to mention that please make yourself you're on mute. If you have any questions, please make sure to put your questions in the chat. We will be monitoring the chat. And after our panelists cover the topics that we have for you today, hopefully we will get to as many questions as we can towards the end of the panel. So yeah, I think that's pretty much it. I just wanted to thank one more time my colleagues, Shohreh Shaghagian, Fatane Zarin Kalam, and Masood Makrichi, my manager, who have been taking a lot of their time to actually put this panel as part of this MLLD workshop together. So thank you very much, and thank you for participating. Back to you, Ravia. Thank you very much.
Thanks, Ali. Good morning, everyone, and thank you for joining us today. I'd like to echo what Ali just said and to thank our organizers at the Thomson Reuters Labs, Ali, Fatane, Masood, and Shohreh, on putting this great panel together and helping me think of interesting questions to ask our experts. So I'm really excited about the panelists we have this morning or this evening when you watch the replay. And I'm hoping we'll have a broad-ranging conversation. I'll introduce each of them in just a minute. But today I really want to focus our conversation on sort of the good, the bad, and the ugly of AI, and sort of the promise that holds for the future of law, and how AI and the law intersect and sort of move each other forward. So we're going to talk about issues of the use of AI in legal systems. We're going to talk about bias and privacy within the ecosystem around AI, and also more about regulation as AI becomes more and more integrated into our ways of living and doing work. With that, I'm going to jump into introducing our panelists. I'll start with Dr. Haan Kavukian. Dr. Kavukian is the Executive Director of the Global Privacy and Security by Design Center. She's also a senior fellow of the Ted Rogers Leadership Center at Ryerson University and a faculty fellow of the Center for Law, Science, and Innovation at the Sandra Day O'Connor College of Law at Arizona State University. Dr. Kavukian is recognized as one of the world's leading privacy experts. She served an unprecedented 3 terms as the Information and Privacy Commissioner of Ontario, Canada. There, she created Privacy by Design, a framework that seeks to proactively embed privacy into the design specifications of information technologies, network infrastructure, and business practices, thereby achieving the strongest protection possible. In 2010, international privacy regulators unanimously passed a resolution recognizing privacy by design as an international standard. Since then, it's been translated into 40 languages, and in 2018 was enacted as part of the EU's GDPR. Welcome, Anne.
Thank you.
Our next panelist is Samuel de Haan. Samuel de Haan is a professor at Queen's Law Faculty and cross-appointed to Cornell Law, my alumni, and Harvard Law. He's a director of the Conflicts Analytics Lab, a global consortium on AI and dispute resolution, and founded My Open Court, an AI-powered legal aid system. Samuel is a member of the Dispute Resolution Advisory Board of EU Intellectual Property Office. He was a cabinet member of the Court of Justice of the European Union. During the financial crisis of 2008-2009, he served as an advisor to the EU and IMF Financial Rescue Program in Latvia. He holds a doctorate from the University of Cambridge and has studied law and dispute resolution at Harvard Law School, the École Normale Supérieure, the Sorbonne, Leuven University in Belgium, and the University of Nice. Welcome, Samuel. And our final panelist is Charles Morgan. Charles Morgan is the national co-leader of McCarthy Chateau's Cyber and Data Group and a former leader of its Technology Law Group. He's the former president of the International Technology Lawyers Association. A nationally recognized leader in cybersecurity, data protection, and technology law, Charles brings deep understanding of disruptive technologies, providing practical advice to help clients fully exploit the promise of innovative solutions while managing their risk. He is a recognized thought leader on the responsible deployment of artificial intelligence. Charles's practice is focused on advising many of his firm's largest clients on their most complex commercial transactions involving IT outsourcing, systems integration, cloud, financial technologies, data security, artificial intelligence, privacy, licensing, e-commerce, and telecommunications. Welcome, Charles.
Thank you.
I'm sure you guys all understand why we've selected these panelists just based on their brief bios. So I'm really excited to hear what they have to say. And with that, I'll kick off our first topic on responsible AI. A lot's been said about the need for responsible AI across all industries and various use cases. And I'm sure that we've all heard of examples of biases that are apparent in algorithms. A couple that jump out to me, for example, is in the US at least, there's been use of an algorithm to help predict sentencing for in the criminal justice system. And this algorithm has tended or has in fact given higher sentencing recommendations and rated the risk of recidivism higher with Black defendants than what is actually true in the population, and has recommended lower sentences for white defendants. Another one that caught my attention earlier this year was when Apple launched their credit card with Goldman Sachs, and many husbands and wives who had, the same financial situation, the husband was given a credit line 20 times higher than his wife, even if she had a higher credit score. So these were, enterprise or sort of real life applications of AI where bias is apparent. And I'm sure others have examples as well. So Samuel, let's start with you. You've argued that bias-free AI is a myth and it can't be achieved in practice. And in fact, you said that not all biases are bad in AI, and AI can help to differentiate discriminatory biases from biases that are grounded in legitimate reasons. In light of sort of the examples I've just talked about and the ones others in our audience I'm sure are aware of, it's a surprising take, to say the least. Can you shed some light on that and walk us through your thinking there?
Yeah, definitely. No, thank you so much. Yes. So as you mentioned, rightfully, over the last few years, there's been a lot of very good research that brings forward evidence on the risks of AI and especially algorithmic biases. But one thing, there are two problems. I mean, they're not problems, but they're two minor issues with these analysis is that they're very much, some of them are omitting the fact that AI is a reflexive process that is just a reflection of how human beings are making decisions. And the problem is not necessarily coming only from the machine, it's coming from us. So in a way, I think AI should be applauded for bringing forward problems that have already been existed that we've been ignoring for 20 years, even more than that. So I think in a way, AI, and it's not my argument, I mean, it's nothing new. I mean, Cass Sunstein and a couple of other computer scientists, or actually at Cornell, have highlighted this problem and described the fact that AI can be a detector, can help to detect discrimination. So, but there's another problem. That's what I have found out in my research is that a lot of the really problematic issues in AI are very much problematic in specific areas where gender bias, racial bias is omnipresent, is very much there. I mean, in the entire data set, like the example of lending practices, the example of criminal law. But however, in my area, for example, in employment law, consumer protection, it's hard to identify. I mean, we tried, for example, to identify gender biases, and it's not that they're not there, they're definitely there, but we can't really see it because there's no real, it's hard to identify, I mean, gender in the data set or race for that matter. However, we've identified other types of biases. For example, the most recent one is that in the context of employment termination, we've realized that during financial crisis, including during COVID, employment judges have decided to grant larger damages to employees, or sometimes not, because they feel like, you know, employees are struggling during COVID, and then they deserve greater, larger amount of damages, or sometimes employment judges decide that, you know, the retail industry, for example, they're already struggling for survival. Why should we grant larger amount of larger notice? So the problem so here there is a bias. I mean, and also a decision where there is no bias in my opinion, doesn't really exist. We're all biased, and the question is, we'll have to be aware of this, and we'll have to be aware of the biases that are problematic. But in my opinion, the fact that a judge decides to grant a notice period that is different in time of crisis, different from in times of economic growth, it is part of the inherent job of a judge. Like, it's part of what we call the reflexivity of the law. There are some external non-legally relevant factors that must be taken into account, or sometimes are taken into account, and sometimes, not always, they are justified with legitimate grounds. The fact that there is, for example, a pandemic. So now we go back to AI. If we start building algorithms that remove that, these, you could call them biases, or I would call them unconventional decisions. We're preventing the law from adjusting, from updating itself, which is essential in law. And we even can cause what some have called an ossification or crystallization of the law. So I think we should be very careful in creating systems that help to identify biases and try to be a little bit smarter at saying, okay, not all biases are terrible. Some of them definitely should be removed, and others, maybe they're part of the decision-making process, and they help in the context of law. For instance, they help lawyers and judges to encourage evolution of the law. So that's my take on this, and obviously that applies only in civil cases, and very much not in the criminal context, where all the harmful biases have been highlighted.
Thanks. That's really interesting. And your observation that AI perhaps can help to expose or help us to confront our biases even more, I think is really interesting. Anne or Charles, anything you'd like to add on that?
You know, it's really interesting when Samuel was talking about crystallization of the law in terms of the interpretations that judges made, etc. AI it would be unthinkable to me that we would entrust AI to do that. It has to reflect the existing situation around you, like we're going through COVID and special restraints, etc. So I personally reject that. I want AI to be as transparent and accountable as possible, because that's how we detect bias. I mean, we all know that there appears to be bias linked to AI, which can have major ramifications on individuals of color and other traits. And from a privacy perspective, we have to understand what the AI is doing. And that's difficult, obviously, for the layperson to do, which is why we need to always look under the hood, as I say, examine the algorithms, make sure there isn't algorithmic discrimination or other problems associated with the AI. Privacy is all about control. It's about personal control relating to the use and disclosure of your personal information. You can't exercise that kind of control if you have no idea how the decisions are being made, the legal decisions associated with your information in the context of AI. So there are many problems associated with AI. Those are a few of them, but it is absolutely essential for us to examine what is going on in terms of the algorithmic process that are being used. I mean, let us not assume any confidence that, oh, well, it's AI, for God's sakes. It knows what it's doing. It knows way better than we do. No, it doesn't. It's created by us humans, and the errors that we make in every day are going to be reflected in AI. So this, trust but verify. Actually, these days, it's get rid of trust, just verify and look under the hood and make sure you know what it's doing and that it actually reflects accurately the goals that you have in mind.
Yeah, you raise a good point. And I'm actually going to throw a question at you that we didn't talk about that you just brought up in my mind. How do we verify and look under the hood when AI and algorithms are proprietary? Like, what is the sort of mechanism for that sort of within a legal system? And Charles, this might be something that you have a view on too, but Anne, curious to hear your thoughts there.
And I'm sure Charles will address this. I'll just touch upon it. Just because they're proprietary doesn't mean that the companies using them don't have an obligation to be forthcoming with their customers, with data subjects whose personal information they're using, in terms of how that information is being used. And is it being used ethically? We'll get into ethics later, but you can't even address the ethical issues associated with this if companies just say, well, it's proprietary, hands off. No way, not in my view.
Charles, do you have a view on that?
Sure. Yeah. So, I mean, let me start by going back to the initial comment on bias and the concerns there. And I think it's important, first of all, to distinguish between two types of bias errors that can be that we're seeing. One relates to the fact that AI systems typically are reviewing massive amounts of data, right? And so there's the possibility of the data bias simply because the data set that has been adopted reflects historical bias or has been poorly chosen. The data quality is off. So you have, the Compass case study that you were perhaps referring to at the outset, where in looking at when somebody was going to be put on parole, the risk of recidivism, there were certain populations that were really adversely impacted by the analysis because the system was looking at some historical data that was already biased in some format. But there's a second type of bias where the algorithm can simply just be badly, erroneously put together. And an example of that is the Michigan Integrated Data Automated System, MIDAS, that was supposed to be taking a look at whether people were committing unemployment fraud. And it wasn't that the data was bad, it was the algorithm itself had been just poorly designed. And so there was an error. 34,000 people were wrongly accused of unemployment insurance fraud. Their wages were garnished. It had immediate impact. The people who put in place the program were, patting each other on the back by saying, wow, we've noticed all of this wrongdoing. We're getting tons of money in our coffers. Isn't this fantastic? But they weren't looking at the algorithm. So to go back to the point, one final sort of anecdotal comment, and that is the CEO of Blue Jay Legal, that has predictive tax and employment law software that goes through case law and tries to help people understand what the likely outcomes are of in employment law cases or tax law cases in Canada. He said, and I found this a fascinating comment, it's really minimizing idiosyncratic bias. And basically what you're left with is just systemic bias. So they look at all of the, to your initial point, Samuel, the individual judges are going to they're going to take their own position. They could have a bad day or a good day. The AI system will help reduce the fact that you've got a bad day or a good day or a bad judge or a good judge. All you're left with is the systemic bias, right? And to your point, Samuel, maybe AI is pointing out the fact that there is more systemic bias than we would like to believe. So all of this to say that it suggests that AI systems, especially to avoid the sort of expert fallacy, whereby if the AI system says the output, it must be right because they just looked at 100,000 data points and how could it be wrong? You have to ensure that for the responsible deployment of an AI system, it's deployed in a context of information governance, looked at from the perspective on an ongoing basis through the life cycle of that AI system. What are the risks associated with that deployment? What are the ethical risks? And this is we're moving beyond privacy here. It's not just privacy. What are the ethical risks? What are the safety risks? Because some of these AI systems are driving our cars for us. And what are the transparency and explainability risks? Because ultimately, individuals want to know if an AI system is going to take a decision that is going to have an impact on their legal rights from just the perspective of procedural fairness and natural justice, those individuals have a right to know what were the factors that were used to determine that decision, and a basic explanation of how that decision was arrived at. And as we all know, with an AI system and a black box problem, it's not always easy to provide that explanation.
Yeah, it's interesting. The principles that you lay out sort of make me think almost of like there needs to be a due process of AI, right? Sort of similar to how there is due process of your constitutional rights or your
due process is a fundamental metaphor for that notion of transparency and explainability. Those are these are principles that are included in the responsible AI framework that we developed at iTech Law and that have been that are, you see them across the board in terms of the new draft EU AI regulation. But without transparency and explainability, in a context where an AI system is going to affect someone's legal rights, you are missing the due process.
Yeah.
I totally agree with Charles in terms of the need for due process, in terms of algorithmic whatever's going on in AI, but we are so far from that. Oh my God. I was going to say, forget due process. I don't mean that at all. What I mean is, let's start with really simple transparency, accountability, looking under the hood, the real basics. We have to start with that because we don't even have that.
Yeah.
Okay.
Please go ahead.
No, I mean, I very much agree with it. I mean, obviously, even whether we agree or not on the concept of transparency and accountability is irrelevant because, I mean, there's a lot of legal basis. I mean, especially in the GDPR, and it's definitely coming to Canada, maybe not in the US. But I think there is also one slight issue with transparency and accountability in the legal context. I mean, we keep saying AI should be explainable. It's Article 14 of the GDPR, very important. But explainable to whom? I mean, I don't think if I was a lawyer, I wouldn't be able to understand a legal judgment. So why are we thinking that, let's say, I mean, American Court or Blue Jay Legal, I mean, and American Court in our context is where Blue Jay Legal makes predictions. It's a legal service for lawyers. So the fact that it has to be explainable, it's accessible to lawyers because they understand the law. But in our context, we do legal aid. Okay, so we help users, workers mostly, to determine whether they have a chance of winning their case. And what we do is we try to explain how the AI work, and we show them the relevant case law. The problem is that these people are not trained in law, and is it really explainable? And I mean, judges are not making law explainable to the public. So why AI should be making law explainable to the public if it makes legal prediction? So I think, I'm not saying again, explainability and transparency is bad. I'm saying just we didn't do a lot of more granular work at explaining what it means in practice.
It's interesting that just to pick up, if I could, on your last point, there's GDPR has some provisions that are limited only to situations involving the use of automated decision making in relation to personal data. But there's a draft EU AI regulation that was issued in April. And interestingly, the transparency and explainability, they refer to it as interpretability obligation in the draft EU AI regulation, it's not to explain the AI to ultimately the person who's affected by the decision. It's the provider of the AI system has to explain it to the person who's going to deploy it, to the company that's going to deploy it. So it's almost, you have to provide a user's manual. So it's an expert speaking with an expert about how the system works. And I find that striking and frankly a little bit surprising that there's no effort to explain how the decision was arrived at to the person who is affected by the decision.
Yeah, that's very much surprising. You're right.
Hey guys, I'm going to move us to the next topic just in the interest of time. We've been talking quite a bit about the limitations of AI and sort of the inherent challenges we see in it, but in a more optimistic sense, we've seen, at least in the legal industry, a lot of success with e-discovery using AI and predictive technologies. And presently, a lot of organizations, my team included at TR, have been focused on building contract analysis capabilities through AI and ML. Looking ahead, sort of beyond that in the next horizon, what do you guys think are some of the most probable use cases for AI and ML in the legal space? Charles, why don't we start with you?
Sure. I mean, AI is going to affect everything. We're seeing it. So started with diligence. We have the MT3 division that did due diligence and e-discovery tools that we use internally, document reviews, that sort of thing. But every aspect of the legal business is being affected by this. So what do lawyers hate the most? Doing our timesheets. We have AI that's helping us complete our timesheets. Yay! Fantastic. We have AI that's helping us when there's a data breach. One of the issues is what types of personal information have been affected, how many people, where are they located, what's our breach notification or obligation. So going through a gazillion documents to find out that may have been compromised, to find out exactly what information, the time it would take to do that kind of analysis has been cut in, dramatically. I think like all businesses, we're a business, right? So not just timesheets, it's also, are our customers satisfied? Are there some indicators that our customers are satisfied? Are there indicators that certain lawyers have, better or worse relationships with certain clients? So helping us to run our business effectively. I think legal research, is already a tool, but I think basically whatever lawyers do, we have a shortage of time. We need to add value. We charge, our hourly rate is too high, and we need tools and processes to make our lives more efficient and bring bigger value to our clients. And so put those factors together and you get a bunch of use cases for AI.
Yeah. You mentioned something about legal research, and Samuel, that makes me think of some of the work that you've done, and your stand that perhaps training on cases leads to the ossification of law, and it's very backwards looking. Of course, that is a big part of legal tradition is backwards looking precedent. But you've talked a little bit about there being this capability, or we should be focusing on how we can develop legal AI projects without training on old law. Can you speak a little bit more about that?
Yeah, definitely. So, and again, this only applies in specific areas where disputes are mostly resolved through negotiation and mediation, dispute settlement in general. So I've noticed that, I mean, and maybe Charles can confirm, when I was a junior associate, or even when I was a European Court of Justice, I mean, when it comes to dispute settlement, I mean, the only objective criteria, to speak in negotiation terms, is the precedent. And most of the time, lawyers were very good at cherry picking. So, oh, this is the right precedent. And from a data science, and I think the audience here is an audience of computer science, it's one data point. And someone in the negotiation process will say, here's the case law. So if you don't agree to this proposal, to this proposed negotiated solution, if you go to court, here's what you can get. So I personally thought that was problematic because it's very much, we call this bargaining in the shadow of the law, but I think we bargaining in the shadow of an isolated data point. So now I've been working with a couple of Canadian law firms and American firms, including BLJ and Fasken, to look at their dispute settlement data and to help them to think about conflict resolution in a more data-driven way. So instead of only in the context of personal injury, for example, instead of just looking at the case law, which is in itself actually quite inconsistent when we talk about personal injuries, sometimes there's juries, sometimes there's no juries. So the outcomes are not necessarily predictable itself. So we look at past negotiation agreements and we build model, in my opinion, on the right data set. We're saying, okay, so here's a case, here's someone, police brutality, they lost an arm. We've resolved 20 cases that are very similar. And instead of looking at one isolated case law, one isolated case that was decided 5 years ago, we look at a series. And the thing is that a lot of law firms, and I think that's an interesting, I guess, innovation in the legal world, is that firms are sitting on very interesting data and they're not really, I mean, until now, they haven't done much with it. And I think what's interesting, and they're really starting to build a more systematic system of driving their dispute resolution process. And I think it's, I mean, yeah, I think it should be applauded in so many ways. Yeah.
Thanks. Let's sort of talk about the role of the human in AI, right? We've talked a little bit about sort of what a judge brings to the case, whether that's their good day, bad day, or their ability to pick up on social trends. You know, that's sort of how law moves forward. But Anne, could you talk just a little bit about your thoughts about how lawyers or humans in general should be involved in decision making as it becomes more and more AI enabled?
The problem is, if you don't have humans involved, algorithmic discrimination will take place and no one will be aware of it and of the harms arising. For example, last year, there was a case that went to the Supreme Court of Canada by a Métis individual. He was a prisoner and he had applied for parole because he was due. And they did an algorithmic review and they said, no, you're likely to recidivate, so we're not going to give you parole. And he challenged that. He took it to court. And what they found was that they used an algorithm to make this determination, but it didn't apply to, he was Métis. He was a Métis Indian individual. And he said, I'm Métis. That, what you have in your algorithm, that formulation does not apply to me, to my population. It applies to people of color and other biases that exist, but doesn't apply to me. And so the lawyers took this to court, went all the way to the Supreme Court. Supreme Court found in favor of the Métis individual. And he said, of course, there's bias here because they just put you into that population, which you do not belong. And so there was no fairness, no accountability whatsoever. And they granted him parole and they didn't, they got rid of that algorithmic program. So the thing is, if you're not careful, if you don't have individuals reviewing this, overseeing this from time to time, the credentials used in the algorithm, the way the algorithm is formulated, and the populations that it should and should not apply to, you're going to get mistakes everywhere. And no one may detect the mistakes because if you don't challenge it, you're not going to have any detection of errors, and this could proliferate. So these are some of the concerns that I have with just relying automatically on AI.
Do you think that those concerns apply equally in situations where individual rights aren't at stake? So, for example, like in transactional, like mergers, like that sort of stuff? Are the stakes as high?
I agree with you. The stakes are not as high, but they still exist if mistakes are made in terms of the calculation and the determinations being made. But I do agree with you. The stakes are not as high if humans are not involved.
Okay. Charles, I think that dovetails with a lot of the work that you've been doing and what your firm has been working on, as enterprises roll out AI within their ways of working, right? I know TR is doing that. A lot of other businesses are doing that as they become more digital first. So how do you help companies think through that, sort of the rolling out and the use of AI and complying with legal standards, as legal standards are sort of nascent and not quite developed even in your space?
Well, a few things. I guess first thing is, frankly, when I'm assisting our clients, one of the issues is that many of our clients are not necessarily developing a homegrown solution. They're using a third-party supplier that's sort of expert. So there's a lot of issues around data ownership, data control, who's going to use the data and for whose benefit. So frankly, there's a lot of legal issues around because there are large Bay Area companies that have a lot of computing power, and if they're to use our clients' data, you want to make sure that they're using it for the benefit of the client. But these systems have to be deployed in the context of a broader information governance system. And so we're seeing our clients putting in place AI ethics committees, and that's something that you wouldn't have seen in the past. To start by asking some fundamental questions about, are there ethical issues associated with the use of this system? You may be deploying a system that is going to, help increase your market share, but is there any concern about manipulation of behavior, about acting in ways that, in fact, could have a negative reputational impact on the company? So there's an ethics committee that is put in place. There's, as I say, a responsible AI impact assessment that's done prior to launching the system. And then there's informational governance through the life cycle of the system. It's not just at the beginning, you go through a process where you check the box and say, look at this risk, look at that risk, we're all good. And then we just deploy, and that's the end of it. Bias issues can arise over time, and they can become accentuated, and you may not notice them at the output, but you would notice them later on. And so there you need to ensure that whatever system you have deployed has traceability, so that you're able to conduct audits of the system over time. You have a feedback loop, so if there are complaints that have been raised, you're able to examine those complaints and assess where there's a data quality issue, a data accuracy issue, or an algorithmic error issue, and who's responsible for addressing any of those issues over the course of the life cycle of the AI system. So it has to be seen in a broader perspective on AI governance.
Thanks. And Samuel, welcome your thoughts there.
I couldn't agree more with Charles. The need for some kind of oversight and governance of the entire system over time, not just at the creation of the AI, but who's actually overseeing this. And the thing is, it has to be someone also with the technical understanding of how the AI works. I mean, you and I can review it and it may look fine at a very high level, but you want someone, in order to determine algorithmic discrimination, someone needs to know exactly how is this thing operating and what is the feedback loop and how do these decisions, how are they made and implemented? These are critical. Because you see, these days, especially, you can put AI into place and the brilliant minds who created it put it in place and then they're gone. And then the company is responsible for overseeing it, but the company may not have the expertise required to oversee it and may not have factored that in from the beginning. And then the holes begin to emerge. You have to have so much foresight in terms of how you're going to operate these systems and ensure fairness and transparency and accuracy.
If I could just briefly go back to the humans in the loop question about what role do people play and should lawyers and experts play, and I'm thinking particularly of uses of AI in the context of the legal system. It's a little bit different in other contexts, but AI generally, machine learning generally works on probability, right? It's statistical analysis of massive data sets. And lawyers are always looking for that one unique differentiating factor in a case that's actually going to have the law evolve, right, over time. Or there may have been, 75 cases that all went one way, but then the Court of Appeal overturned one of them, and the law thereafter is going to go in a new direction because a higher court intervened. And so the skill that a lawyer brings is often about being able to distinguish one case from all the others. So the role of the lawyer in that context is absolutely critically important. And to avoid this, the comment earlier, Samuel's comment about the ossification of the law, we're always trying to distinguish from precedent, and that's how the law evolves. So I think the tools will help lawyers work more efficiently, but the lawyer always has to be in the loop, and the judge always has to be in the loop.
Absolutely.
I may have one comment. I mean, obviously, I'm not as much an expert in this area as my two co-panelists, but I've noticed an interesting proposal in the legal community related to what you were asking earlier, Raya, regarding when the algorithms and the data set are proprietary. So I think, one problem is that the company may say, I cannot share. I mean, if we make it explainable, then we're exposed to algorithmic hacking. Someone will copy our research, our work, and that's a lot of investment. We don't want to do that. So I think one solution I found quite interesting is, not like making laws that it will encourage or even force these companies to share their proprietary algorithms to the regulators. And it's not new in the financial industry. I mean, pricing models have been used for 20 years, and they share this to the SEC, and in a way, it's actually better because, as Anne was saying, we need people with expertise, and the average person will probably not know what the law is. Really, they don't have a basic understanding of the legal concept nor of machine learning. So I think one good middle ground approach is making sure there is a regulator that is capable of assessing, how the models work, and based on the idea that people will trust the regulator, that's good enough.
Yeah, it's interesting you pointed. I mentioned the draft EU AI regulation that was published in April of this year. That's exactly the approach that they've adopted. They based a very interesting choice, but the EU AI regulation is based on product safety law. That's the paradigm that they adopted. So it's just like keep people safe. And so there's much less emphasis on informing, as I say, the individuals who are ultimately affected by the outcome. It's more about the providers who develop the system have to prepare a huge amount of technical documentation that they share with the regulator. There's a process of self-certification where at the end of the day, after going through a rigorous process with the data analysis, you get the CE stamp, the same way that you have on toys and things like that. And then because they've been rigorous in the process of assessing the safety, if you will, of the product before it's deployed, the view is that people should accept the product at the end, and we're all good. But there is a lot of information that's shared with the regulator, much less, almost nothing that's shared with the end user.
That's fascinating. Yeah. Go ahead. I'm sorry.
No, I agree with both of you. My only comment is, having been a regulator and knowing what regulators' offices usually consist of, you need to upgrade in terms of hiring the kind of expertise you need to do this kind of assessment. So as long as they do that, I'm totally on the side.
Sorry, sure that. No. I was just about to say, and I think it goes back to what Charles was saying earlier, and also what I've heard in a lot of conferences, where the panelists were criticizing Canada and the US for not having a GDPR. But the thing is that and even the EU, honestly,
we do now. Bill 64.
Yeah, you do.
Quebec
it's true.
That's right. Bill 64 is
yeah,
great.
Bill 64, and that was, but 2000, the GDPR was in 2018, and now it's almost 2022. So there's been a lot of criticism and pressure. But even, let's say, in the context of the US, I actually don't think we need a GDPR. Why? Because there's already a lot of there's already strong legal basis to condemn algorithmic discrimination, because discrimination is already a problem according to the law both in the US and Canada. And same thing in the EU, what you were saying, Charles, most of their new laws on AI is based on the existing treaty and the provisions on product liability. So we don't need to be like changing the entire regulatory regime to argue from a legal standpoint that algorithmic discrimination or unsafe AI is problematic, because the law is already there.
Let's move to a related topic. We're talking about the end user who's affected by AI, and we're talking about sort of decision makers and regulatory and governance players. But what about the lawyers themselves who are using AI in their work? And one thing that we've learned at TR is lawyers have a lot of skepticism around AI, or they want it to be perfect. And so there are some frustrations with like the limitations of AI as it is today. But I'd be curious to hear thoughts on how we can build trust of AI in the legal profession. Maybe, Anne, I wonder if we should build trust of AI in the legal system based on your worldview. But just curious generally on how to get lawyers to want to use AI as part of their day-to-day work and rely on it as sort of like a colleague.
It's hard asking me that question, because I don't have great faith in AI right now in terms of what's happening under the hood. And you see, there's such a trust deficit right now everywhere. Trust is waning. So if anything, you're going to have to build that trust. And with lawyers who are already skeptical, and this is why I want to turn to Charles and get his view as lawyers, I think it may be a difficult process. If you've got lawyers who already start with having little trust in AI, which I think is actually warranted, then how do you build that trust? And that's a question I'd like to put to Charles.
Yeah, well, I think a few things. First of all, I think this is just a sort of a general factor, and it applies to lawyers like it applies to anyone else. Lawyers are going to have trust if it works. So this is the brilliance of Apple, is like, it's simple, it works, good, I'm good. But if it doesn't work, then there's a trust breakdown. I think lawyers, and so again, the level of scrutiny, I think, for lawyers for any AI system is going to vary, and the need for building that trust will vary depending on the criticality of the outcome. So is an AI system that helps me fill in my timesheets, I don't need to look at how that works. If it seems to make my life simpler, I'm gonna adopt it, right? But if I'm preparing for trial and the value of the dispute is enormous, and I'm I get an outcome from an AI, some sort of recommendation or a summary that doesn't, it doesn't compute with where I think the law should be going, or I feel is not going to be, is not consistent with my years of practice. Two things. One is I might start to ask, how did this system come up with that outcome? Because it doesn't make sense, right? So I will want to have that explainability. What are the data? What were the data inputs, and how was the outcome derived? And I'll want to know, just like when you're writing an opinion, what were the assumptions, right? What are the assumptions? What's the scope of the opinion? What's the scope of the review? These are. I mean, we do this all the time when we opine on anything. We start by saying, what are the assumptions? What's the scope of the analysis? And I'm only going to comment on that basis. Mm-hmm. So minimally, when we're using an AI system that's going to help us with a legal analysis, we need to know what's the scope, what were the data sets, what was the basic logic that went into coming up with that outcome. And to be able to trace that or audit it when there are outcomes that don't seem to make sense to us. I mean, we could learn a lot, right? There's a possibility that our 20 years of experience, we've just been making a mistake, and the AI system can teach us something. I'm learning all the time, but when there's an odd outcome, we are going to want to be able to test where that outcome came from. And in order to be able to test that, you have to have elements of traceability. You have to have some explanation as to how the decision or outcome was derived.
Exactly. And you need to be able to challenge it, if necessary, look under the hood.
Yeah.
So,
but if anyone on the call can like mail timesheets, I'm telling you, that's number one.
It's on our roadmap. I'll say that. So one thing sort of you bring up that's interesting, right, is there could be the AI's performance based on how much data it's been trained on, how good that data is, how confident we feel in that. But there's sort of a second issue about whether certain tasks are suitable for AI at all, right? Which might be sort of that stuff you're getting into, and sort of where the lawyer's judgment is required. But Samuel, curious if you have thoughts on that, sort of how we draw the line, and maybe it's not a clear line, but how do we sort of parse that about tasks that are suitable for AI and those that should sort of still remain maybe in the analog domain?
Yeah, I mean, I don't know if it's possible to draw a line between what's suitable for AI and what's not suitable for AI. However, I'd say there are some areas where I think AI can have an impact in every area, but I think it would depend very much on the degree of intervention of the AI. So if I can say that. So like the main difference will be automation versus assisted decision-making. So for instance, I strongly think that AI-enabled adjudication is very much problematic because it would result to the ossification of the law, which was as I discussed before. And I think assisted decision-making could very much play a role in many areas. I think, however, even if it can play a role, we have to be extra careful, for example, when it comes to criminal law, but maybe a little bit less careful, not less careful, but approach the problem from a different perspective when it comes to transactional work. But however, I don't think I can say, or maybe someone else can share different views, but I don't think AI shouldn't play a role. There's an area where say like it shouldn't touch. However, I'd say, it's more about how we use it rather than whether we should or should not.
I just want to, there's a couple of comments that have said, I understand where they come from, where they say, well, if it affects an individual, it's really important, but if it just affects companies, it's not. I don't think our clients would agree with that, actually. And I think, we've seen scenarios where a misplaced comma costs a company $1 billion. Right. So you got to be careful across the board.
Yeah. And any thoughts on that?
You
Sort
know,
of
I was
where
going
to
to
draw the
say,
line.
if it affects individuals' lives in terms of AI making decisions, like the example I gave in terms of the release of an individual from a correctional facility, that kind of thing. If it has major implications on individuals' lives, I'm not saying don't use it, but always have some system where it can be reviewed for accuracy, for accountability. I think you need something in place that doesn't just automatically assume this is fine and we're just going to take all of these without any further examination. We need some system of review.
Sure, great. So I'm conscious of time, and I want to make sure that we have time for our audience to ask questions of our panelists. So I'm going to open that up. I'm going to check the chat, but Farhana, I see that your hand is up. So if you have a question, please go ahead.
Hello. So thank you very much for letting me ask. It's not a question, but I just wanted to, as an AI researcher and computer scientist, I wanted to share some thoughts based on what the discussion was, the kind of discussion that we had so far. So about AI, what we should, use AI for, the terms, the term artificial intelligence came up and was used for a very long time based on rules, okay? So where there are very strict rules, you can use AI. If the rule is not specified or it's a bit subjective as, in legal cases, the adjudication. In that case, no, okay? It has to be an assistive technology. So there has to be some human involved. AI can help provide the information, but not as the main adjudicator, right? So when there is rule involved, when there is a lot of search, so the second big use of AI is not rule-based decision-making, but when we need to search a big space of information, which is, you have many legal documents, you have precedents. So AI can definitely help search that space and come up with some suggestions or some similar cases that, can help the adjudicator to look up and make a decision based on that. There was also discussion about, and if there are multiple decisions, like the other thing, which one is the best decision? So that is the third application of AI is based on search. You find several options. Which one is the best option? I think we have not gone at that level yet, particularly in case of, where there has to be some kind of subjective decision or humans are, able to make better decisions. In these cases, also AI is not suitable, but again, AI can provide you those three options, or four options that can be used by the human adjudicator to make a decision. So I think these are the useful things of AI. Also about the explainability, there are now research on different kinds of AI, deep learning model, attention model that can highlight information which basically led to certain decisions in the precedents, in the prior cases. So that way also AI can explain that what points were more important and what points may have led to certain decisions in previous judgments. So these are all important things where AI can, I think, definitely contribute. Regarding ethics, there is an ethical issue, bias issue, even in human decision making, which we have found in our research. We have worked with Samuel on legal data analytics, and we have found that certain decisions were, maybe based on factors that shouldn't have been taken into account, or we were surprised to see that these factors actually led to certain kinds of decisions. So again, those things, exploratory kind of research, AI can help. So just a few comments. Thank you very much.
Thanks for those observations. Panelists, any reactions or thoughts on that?
Yeah, actually, I mean, I realized that my answer to your previous question where it was incomplete, and hi for Hannah. So actually, and Hannah's comment made me think about my answer, because I realized that with one of the projects I've been working for Hannah on personal injury, I actually realized that AI didn't work. And AI doesn't work because the data sets, the case law was inconsistent. So it was impossible for the AI to pick up on any kind of pattern, because judges were all over the place. So that's one thing that I realized, like, that in this case, AI shouldn't be applied. And there's another thing I forgot to mention as well, is that in some areas, and I think I'd like the opinion of my co-panelists on that, where we've identified a bias, or may not be necessarily a bias, but for example, an extra legal factor that severely influenced the decisions of some judges. Like, for example, in the context of worker classification, so determining whether a gig worker is an employee or an independent contractor, we realized that the industry, which is not supposedly, according to the law, supposed to be taken into consideration, it was apparently heavily taken into consideration by the judges. So now that's what I would call a permissible bias. But I'd like to test this idea with my co-panelists. Like, what if judges, let's say in the construction industry, it seems that there's a lot of issues when it comes to how employers are treating their workers. So it seems that the judges are more stringent with construction industry than they are with other industries. But that's definitely, I'd see this as a bias. It's a definition of bias, according to psychologists, is a leaning of the mind. So they chose to be harsher because they know that in the previous cases, construction workers are poorly treated. So I'm like, what should we do when it comes to replicating that model into an algorithm? Sorry, Ryan,
I'm not an employment lawyer, so I'm not. I hesitate to comment on this. But just one thought that comes to mind about construction is there is the health and safety aspect to it. Like, I'm not sure whether an overriding factor about proper treatment of employees in the construction industry is particularly an area of concern, because people die, because people get injured, and so there's that. That's an uninformed guess.
But an interesting one. I like it.
No, just from an abstract term, I think it's for lawyers. It's really an ethical question when a non-legal variable interferes with the decision-making process.
Yeah.
Let's say it's like for immigration case, I've seen data sets where showing like the country of origin is a problem. Okay, so that's a racial bias, that's a problem. But when it comes to, like, for example, the industry, I'm like, and you say like there are many reasons why judges are making this decision and not, and it could be legitimate. So what should we do from a computer science standpoint? Should we remove that variable as if it's like a bad bias? Or should we leave it in there because that's part of the law? That's part of this. That's part of the judicial decision-making process.
I think there are some assumptions in there too, to Charles's earlier point. Like, what are the assumptions we're making here, right? That somehow the law itself is neutral, right? There are tons of biases built into the law, not just the systemic application of the law, but the law itself, right? Those in power create the laws. So there's inherent biases in the way laws are applied. And so in some ways that might be intractable. Is that even a thing that AI can solve, or is that just sort of the nature of politics and governance? But it might not be something for an algorithm to solve, but again, it is something that an algorithm might expose. I want to make sure there's a couple more questions here in the chat.
So a quick comment while you're looking at that.
Sure.
First of all, I just wanted to comment on the earlier issue around explainability and would it reveal trade secrets, and is this a concern? And I think that clearly you have to find the right level of explainability. You don't have to force companies to reveal their secret sauce. This is, the recipe of Coke is not going to be announced to the public because of an explainability requirement. But you do need, I like the analogy, and I think it's relevant to this discussion of procedural fairness, natural justice. in administrative law, you have to give some basic information about the factors or criteria that go into the decision-making process, right? And I think that's, so, you know, whether we're talking about the construction industry or whether we're talking about other scenarios, you know, the reasoning of a decision is going to be based on these are the 4 criteria that I took into consideration in coming to the outcome, right? And you don't have to reveal trade secrets when you talk about the describing the basic factors of explainability in place.
I totally agree with Charles. There has to be some information provided. As he said, it doesn't have to go into the secret sauce, so to speak, but you have to have some communication relating to how does this work? It can't be a black box and just, you know, trust me, everything's fine. No, you can't have that kind of situation. Some kind of rule-based decision-making, like something has to be revealed, explained as to its use.
Yeah. How do we make sure it's not arbitrary, right?
Yeah.
Sort of in a court system language. So that actually ties well with the question we have from George Sanchez. So even if we have experts and lawyers assessing these AI algorithms and talking about what's underpinning them, how can we be sure that their assessments are good? Remember the risk models deployed by experts in the financial industry in 2008. Those models were deployed under substantial consensus among highly informed individuals. How will it be different in the legal domain?
Well, if I could just start, it can't just be in the legal domain that lawyers are doing this kind of assessment. You need people with expertise relating to machine learning, artificial intelligence, how those things work. I mean, that's code. A lot of lawyers I know don't know any code. I'm not trying to make any disparaging remarks, but they're experts in law. But the coding language, machine learning, et cetera, is completely different. So you have to have some of that expertise involved in making these assessments.
Yeah, I agree entirely. And this is an area where, I mean, first of all, we're not going to be able to solve the problem entirely. There's always going to be risk. And so it's about risk mitigation. It's about, you know, going through a process. And as the question pointed out, you know, some very bright people using some very sophisticated technology and in theory, having the best information completely miscalled the financial crisis and so on. So, and that's going to happen again. But I think in any situation where you're deploying a new AI system, it's going to require cross-pollination of expertise, and there are people who are experts in developing algorithms and coding. There are people who are experts on data quality and assessing, you know, data readiness. And then there are domain name experts who are going to help point out some of the intangibles that the data scientists just wouldn't have seen. And this is why I think there's that it's part of an information governance process, and why it makes so much sense to have, as I say, first of all, a process that's going to involve a feedback loop over time. One that involves, you know, rigorous assessment up front from a multidisciplinary team, and then one that allows for review over time based on feedback on that's based on the outcomes that have been derived over time.
Great. Well, we are coming up on time. I want to thank our panelists today for this really interesting and insightful conversation. I'm going to be emailing you guys with my follow-up questions separately. And I want to thank everyone for dialing in today and participating with us. And again, I want to thank TR Labs for organizing this conference. Thank you, everyone, and have a great week.
Pleasure. Bye-bye.
Bye-bye.